Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to talk about and hopefully wrap up my discussion of Bill C-21 by looking at some sort of leftover odds and ends provisions, as well as some discussion about what you can do, because a lot of people have asked, have said, hey, Runkle, thanks for letting us know that this is a bad bill, but what do we do about this? How can we take meaningful steps to try to get this changed? And so I'll talk a bit about sort of what you can do and how to go about it. So let's first look at some odds and ends that they changed. One of them is, authorizations to carry or transport. And they have now sort of split things up. So they have a chief firearms officer who's responsible for issuing authorizations to carry, referred to in paragraph 20B, but the commissioner is responsible for issuing authorizations to carry, referred to in paragraph 20A. So what they're doing here is they're taking away the power from paragraph 20A and from the chief firearms officers and giving it to the commissioner. Now, why are they doing that? Well, the chief firearms officers are, provincial in provinces that have adopted the Firearms Act. Now, the commissioner is federal, period. So what they're doing is they're looking at what's going on. They're seeing, Saskatchewan appointing their own chief firearms officer. They're seeing Alberta doing so. And they're saying, okay, well, we want to take away this paragraph 20A power. And you might be saying, well, what is 20A? Well, that's authorizations to carry for protection of life. So protection of yourself. Now, 20B is, if you're an armored car driver, that kind of thing. So really, their concern here is fairly clear. They're worried that maybe these provincial chief firearms officers won't play ball, won't toe the sort of party line. And the party line has been that the application for an authorization to carry for preservation of life, you don't get one. You just, unless it's the most, extreme, weird circumstances, you don't get one. They jealously guard any information about the type of people who get them, but it's always something like, 0 to 2 in Canada at any given point. So almost nobody gets these. I suspect that they were worried that that might change. And so that's what that seems to be about. There's some other provisions here that I didn't really get to before because they're just kind of small provisions. One of them is an authorization to disclose provision. So the commissioner, the registrar, or chief firearms officer, if they think that you are involved in some sort of firearm trafficking, then they can provide basically all the information that they have about you to the police. Now, they already did that. So I'm not really sure why this provision is sort of setting up this to specifically allow it, because that was already the practice. Nobody really was in a position to complain. That makes sense to me. I am against people trafficking illegally in weapons, so I got no beef with that section. It makes sense to me that they would share information as part of those investigations. There's also some transitional provisions here. One of them is kind of interesting. So this is automatic authorization to transport for a license renewal, which is basically taking gunsmiths and verifiers out of license renewals. It's done in a really interesting way. It says if subsection 4 sub 3 of the other act, which would also impose these kinds of restrictions, comes into force before subsection 18 sub 3, then replace the act with, these provisions. But if 18 sub 3 comes into force before subsection 4 sub 3 of the other act, then that subsection 4.3 is amended by replacing. So basically it'll do the same thing. Interestingly, they don't actually, or they note, if subsection 18 sub 3 of this act and subsection 4 sub 3 of the other act come into force on the same day, then 4 sub 3 is deemed to come into force before 18 sub 3, and subsection 6 applies as a consequence. all of which is basically saying the Firearms Act is going to be changed as follows, but in this really weird, convoluted kind of way, which kind of buried it into the transitional provisions, which not a whole lot of people look at. I think this provision is kind of dumb because it makes sense to have, and in fact, the courts have previously held that it makes sense to have gunsmiths on these. As an example, let's say it's Friday and it's 5 p.m. and I'm shooting my gun and I get a stuck cartridge, so this cartridge is stuck. And, let's say it's a circumstance where I don't think it's safe to fire this cartridge. So, I've got a loaded firearm. I can't really deal with it. I need help. I need somebody to come and help solve this problem. Well, the firearms office is closed. They close at, I think it's 4, might be 4:30 on Friday, and they're not open again until Monday. So if I want to take this to a gunsmith, I need permission to do so, and I can't get that until Monday. Well, what do I do with this gun in the meantime? What they have quite seriously suggested in court is that I call for the gunsmith to make a house call at the range. Now, I don't think there's any evidence that gunsmiths make these kinds of house calls because most gunsmiths I know have a substantial waiting list and, they don't drive around and come to you. You bring your gun to them. That's how that works. But for some reason, basically, they lost court cases over this in Alberta and Ontario and a few other places, and they've been really salty about it. So they've pushed to have this changed back because eventually, after this became an issue with the court cases, Stephen Harper, I believe it was, essentially made them add gunsmiths. So now they're changing this back. I don't get it. I think gunsmiths make sense. I don't think, even when you go to people who are anti-gun and say, hey, should I be able to take my gun to a gunsmith in an emergency like this? They say, yeah, that makes sense. So, yeah, that's another provision they're changing. Anyway, those are kind of the leftover provisions. Oh, one additional one here. So there's a provision here, and it's replacement of 10 and 10 with 14, which doesn't seem like it's doing a whole lot, but what they're doing is they're actually increasing the maximum penalty for certain offenses from 10 years to 14 years. So that's the number they're changing, is the maximum penalty number. Now, those offenses include possession of prohibited or restricted firearm with ammunition, possession of weapon obtained by commission of offense, as well as some weapons trafficking offenses. Now, in terms of this, that may increase the sentences people get slightly, but I'm not a huge believer in, long sentences as a solution to this. I just had the opportunity to attend a talk, which was a talk on gun violence, particularly in Toronto. It was called Gun Violence as a Public Health Issue. And when they were talking about the causes of gun violence in their community, they weren't talking about, people aren't getting enough, as a sentence. They also, for that matter, weren't talking about we need to, ban firearms. What they were talking about was, the sources of this in terms of trauma, in terms of, poverty, in terms of lack of opportunity, these kinds of issues. Sentencing is a really bad way to stop a lot of these offenses because while you might be able to sort of get one person, so long as the underlying causes are there, there's always going to be another person willing to step up and fill those boots. So you really have to, deal with the source. It's like saying, oh, well, my house keeps flooding. And so, I make sure I have buckets to clear it out. Well, eventually you're going to want to deal with your roof. That's what we need to deal with here. And so saying, oh, well, we're going to get a bigger bucket, you're still going to have house flooding issues. So I'm not a huge fan of that, but I know some of my viewers will be saying, hey, that's a great change. We can disagree on that. Now, The other thing people want to know is, what can I do? So you're going to want to, have communication with, your representatives. You can look up and find who your local member of parliament is. And, they probably have an email address. Send them an email. Let them know what you think. Be polite. Be reasonable. Because if you come in and you are swearing at them and you're an angry, crazy person, all that does is it communicates to them that, your opinion is not worth anything. And in fact, maybe that they're making the right call and going after you. So always be unfailingly polite. Talk about, your ties to the community. Talk about the fact that you are, that you're employed, that you are, a long-standing, if you do volunteer work, talk about that. These kinds of things, and explain calmly and rationally what issues you have. Be succinct. Nobody wants to read 20 pages. So hit your, 3 best points and, hit them quickly and sort of persuasively and, again, politely, and then move on, because if you send them 20 pages, no one's reading that, especially not a, a parliamentarian with lots to do. Not even their aide. Their aide isn't going to read that and summarize it. So also, I recommend sending physical mail. You can send mail for free to your parliamentarians. So why not? All of this, is a useful thing, but really importantly, always in your communications, you want to be, polite and rational. Don't pick fights. You also may want to consider, writing letters to the editor. And again, calm, rational, persuasive letters, not angry rants. If you are not the sort of person who can discuss this calmly, then either don't do anything, don't undermine the cause, or get someone else to help you with it. There's all sorts of template letters out there, and, maybe I'll draft one at some point and post it probably on my Facebook page, just because, it's worth making these steps to communicate. And, you can talk about what issues are personal to you. If you are an airsoft person, talk about the airsoft issues. If you are a gun person, talk about the firearm issues. But the other thing I don't really recommend is that there's a real tendency to say, you know what, I'm going to throw those other people under the bus. Maybe you're a gun owner and you're going to say, you know what, that airsoft stuff has no use in society. Do it to them. Or maybe you're an airsoft, person. You want to differentiate yourself from those bad gun owners. The problem is that this is a losing strategy overall. We do much better working together. It's much better to have allies in a fight. And eventually, if you are willing to sort of cut out other parts of the community, you run out of people to throw under the bus. And when they eventually turn around and come to you, you're out of friends. So stick together early, stick together. It's a, that is the winning strategy long term. Either, we're all in the same boat, and saying, oh, well, the hole's at the other end of the boat, that's not a great move. The other thing is, I've seen people in the airsoft community saying, oh, well, maybe we can make a pitch for, orange tips and that sort of thing. And I can tell you that's going to last you, if you make that compromise, it's going to last you about 5 years, maybe. Maybe longer. I don't know. I can't say for certain. But eventually they will say, you know what, we're getting too many people painting the orange tips. And, even if it's just going to entirely fantasy airsoft guns, you saw the takedown with the stormtrooper dressed as a stormtrooper holding a Star Wars styled gun. Remember as well that a lot of movie guns and a lot of these fantasy guns are styled off of existing firearms. And so, if you say, hey, we're fine with this, you're going to see a push for whatever you move to. It's just, you're buying time, maybe. But buying time is still losing the fight. It's just losing the fight a little more slowly. So this is a time, I think, if you're an airsoft person, to really be pushing for ideally, the law should recognize airsoft as a thing, as a legitimate, pastime, and actually create specific exceptions for airsoft and take it out of this weird legislative loophole gap that it was in. I mean, come on, this is in the age where we've got, our politicians are advising us that we need to do more healthy things. We need to spend more time running around and less time doing what I'm doing right now, which is sitting on a chair getting fatter. Why would they want to take away these, these activities from us? So anyway, those are some of my thoughts. Lots of you may have other thoughts as well as to what you can do. Leave them in the comments below. We are strongest as a community. We are strongest working together. So I want to keep that going strong. Please, if you've enjoyed this content, like this video, please share it with your friends so that they can see what steps they can take. Please subscribe to see more content. These are issues that are not going away anytime soon. This is, not a sprint. This is going to be a marathon. So welcome aboard, I guess, is all I can say, because there's a lot of people who are now just getting into this fight. And I also want to thank my supporters, especially my Patreon supporters at the $50 level. Demo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, Jason Elliott, North Central Process Service, Jean-Guy Toussaint, and Kyle Martin. At the $20 level, Cameron Johnson, Dale Nesbitt, Andrew Elsich, and Sights and Arms Limited, as well as a number of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching. I hope this has armed you with knowledge, and we're all in it together. So here's to the struggle coming up. Cheers.